And welcome to Right to Read Advocacy's webinar, What You Need to Know About Your Rights in Special Education. We are very fortunate to have Attorney Laura Heneghan here with us, Law Office of Laura Heneghan, Special Education Law, out of Fairfield County, Connecticut. She has a lot of good information to share with us on this LEAP Day, so we are going to, dare I say, leap right in and get started. We will take question and answer mostly at the end. If you want to put those in the Q&A section, that would be helpful. And we'll be sure to save time at the end of the webinar to answer those questions. All right. Thank you, Laura.
Thanks, Jen. And thank you, Right to Read Advocacy, for having me, and happy LEAP Day, everybody. Really happy to be here and talk about some rights that you have in the special education process. So I'm just going to jump right in, I hope. Assuming let's see. There we go. So I'm a lawyer. Of course, we need my disclaimer first that nothing here is interpreted as direct legal advice. It's intended to help you understand the process in this area of law. And if you need specific legal advice, you need to consult an attorney. We do not have an attorney-client relationship as a result of this. And I practice currently in Connecticut. I'm admitted in New York. I don't practice currently in New York. So some of what I'm saying is specific to Connecticut. There are federal laws regarding this, so a lot of it applies to everybody. And I'll try and make that distinction for those who are not in Connecticut. So who I am and why I'm here. As we know, Laura Heneghan. First of all, I'm a mom of kids with disabilities, which, as many of us, is why I'm practicing in this area of law and doing this kind of advocacy. I've had experience with dyslexia and autism and anxiety and a lot of those areas through my 3 children. And that pushed me into special education law, which I'm really happy to kind of help others through this journey, because it is a journey. And I'm here because it's important that parents know their rights. Doesn't mean that you have to assert them. And we'll kind of get into what that means a little bit, but knowledge is power. And that really is the truth when it comes to this stuff. I am very much a collaborator when it comes to this, trying to work things out, because I find that that is beneficial in these kind of situations. And when you're working with your school district, I would encourage you to try to be collaborative while understanding what your rights are. And it's because you, as the parent, have guaranteed civil rights regarding your child's education. And that seems simple. They come from mainly these 2 laws. There's some other ones that we'll touch on, but these are the two big ones. The IDEA, the Individuals with Disabilities Education Act, was created in 1975, says it ensures all children with disabilities have the opportunity to a free, appropriate public education, what's commonly known as a FAPE in the large bucket of acronyms that we use in special education. And then Section 504 of the Rehabilitation Act provides that qualified individuals and protects you from discrimination based on disability and other things, and provides students with disabilities a free, appropriate public education. It's a little bit different of a FAPE than the IDEA FAPE. It's more access, but we're not getting deep into those things with this. Just know that you have rights under both of these. So why is this process so complicated if you are insured these, federal civil rights? I'm not a cynical person, but a lot of it comes down to money, that the people making the money decisions are not the people interacting with your child every day. The teachers and the OTs and the PTs who are giving loving care to your child all day are not the people that hold the money buckets at the top. And therefore they're not the decision makers. School budgets are really complicated things, and sometimes how you resolve something may change based on what bucket the money has to come out of. And just an example of that, there are state-approved special education schools that the PPT can place your child in. If that happens, they can get back what's known as excess costs. And again, I'm really simplifying this. If the cost of that student is in excess of a certain percentage, the school can apply to the state to get back a portion of that money. What that means is they may be more likely to place a child at a $90,000 state-approved school rather than give you $50,000 for the school that you want to send your child to. it doesn't make logical sense because there's more going on kind of behind the scenes, if that makes sense. The IDEA is the big law that we use in special education, and it is a federal law. So there are ways to enforce all laws. How does this get enforced? At the federal level, it's by withholding funds administered through the Office of Special Education Programs. That rarely happens. At the state level, there's withholding of funds until whatever the non-compliance is in a district is corrected. But the way that they determine non-compliance is from a self-reporting manner. So there's not really a good way that that enforcement works. Then you, as a parent, you hold these rights. How do you enforce them? The big ways are due process or compliance complaints. And we're going to talk a little about that. So when you enforce your rights as a parent, and there are some issues that come up just in the fact that you are your parent in this kind of big system that's happening in the school districts. So one is you don't know your rights. We're going to hopefully help a little bit of that with this presentation. The intimidation factor is, it can be really huge. Especially when we were in person, I think it was worse. You'd walk into the room after you wait in the lobby, and you know the whole team is assembled, and you walk into the room of 12 people who are all there to talk about your child. That's really intimidating. It's a little bit better to me now that PPTs, when I say PPTs, I mean the team meetings that you get together to talk about the IEP. Those are, for the most part, virtual. There are some in-person ones that take place, but it does kind of eliminate that like home court advantage to me. So I like that model now. Sometimes you feel like parents are deemed to have unrealistic expectations of their child. And we're going to talk a little bit about this too. Like what should you be expecting from your school district? Because there's what would be the best thing for your child, and then what you're legally entitled to. And those can be two different things. So we want realistic expectations out of what your legal rights are when you're coming out of these meetings or this system. A lot of parents get intimidated and worry about retaliation against either the child that they're fighting for or their other children in the school district. And that can be a really intimidating piece also. I don't actually see a lot of issues with that, but it is definitely, a realistic concern. Parents feel powerless rather than the actual expert on their child, because again, you're walking in trained teachers and psychologists and all these professionals, but you know your child better than anybody else in that room. And you should really know that and own that. You fear challenging the decisions that are being made by the team. And one of the things we're going to talk about is you are an equal member of that team, though it may not feel like it. Legally, you are an equal member of that team. And sometimes it's hard to find legal support advocacy services, whether it be financial or geographical. There are some states that have very few attorneys or advocates. Even within a state, it might be difficult. Again, one of the COVID positives was that a lot of us are practicing statewide because all of this is virtual. So hopefully that opened up a little more advocacy efforts for people to have access to. So you all know your procedural safeguards. When you go to a PPT meeting, when they see in person, they'd hand you this tiny little folded thing that was in this tiny, tiny print. And they said, here's a copy of your procedural safeguards. Do you need another one? And without reading it, you'd say, no, I'm fine. That really outlines a lot of what your parent rights are. The district has to give you a copy one time a year. And also, the first time you ask for an evaluation, if you ask for a copy, they have to give you a copy. If you file for a due process or state complaint and disciplinary action is taken against your child, that is a change in placement. So a lot of it now is through the computer. I see most of it. You get in the invite to the meeting, and along with that is a copy of your procedural safeguards. They will ask when the meeting starts, did you receive your copy of them? And they're pretty good at that. So now we're going to kind of get into what your rights actually are. One right that there's a lot of misunderstanding about this, and I think part of it is the nomenclature of it, the what it's called, prior written notice. Sounds like something you get before, and it actually isn't. So the prior written notice is, what it says is no later than 10 school days before the PPT proposes to or refuses to initiate or change one of these things, the identification, evaluation, or educational placement of your child. So you have to be notified, and how it generally happens is as part of the IEP, there's a piece of it that's called the prior written notice. It used to be in Connecticut before they changed the system, it used to be in the IEP document. Now it is a separate document in your IEP system that you get. And what it is doing is telling you what the school is proposing to do or what they're refusing to do. And there's an implementation period. So within your, after your PPT meeting, you're supposed to receive the IEP within 5 days, and then you've got 10 days to refuse or agree to it. Some states require parents to sign them. Connecticut doesn't require you to sign it, but it gives you that period of time to basically disagree with what is happening in that document. So it's not prior because you're getting it after the PPT, but they're notifying you of these things that are potentially going to change. It has to include what they are proposing or refusing, why they are proposing or refusing it, any other options discussed, what they use to make that determination. And if English is not your first language, it's got to be provided you in your native language if possible. So it's not as confusing a thing as it sounds. It's just what they are proposing to do and why, really. You do want to pay attention to it. And the biggest thing that I find is a lot of times when it says what assessment, evaluation, or record was used, it says like teacher observation. Well, that's usually not a reason to make a change in one of these things. The other important piece about prior written notice is if you disagree with something in the meeting pertaining to any of these areas, you want to make sure that that's reflected in the prior written notice that you disagreed with them. Or let's see, you make a request of them. I would like you go to the initial and they don't find your child eligible. That's got to be noted in the prior written notice. And you would say, please note that. Okay. And then when you get the document, you want to make sure everything is correct in there.
And can I interrupt? If it's not correct, how does a parent correct the prior written notice if they find it?
So what I would do is I would in writing put what you disagree with, and this would actually go to the entire IEP. When you get that document and you get the prior written notice, if there's anything you don't agree with in there, you want to document it and send it back to the administrator and say, I disagree with what the IEP says. This is what was my understanding, and please make this part of the record and part of the IEP and include it in my child's, educational record. The biggest piece that I generally see is what we just talked about, that the things that they used to make the decision where it wasn't clear that they used evaluations or other things. The other piece is the parent input. The parent input box is this tiny box, and you might go in and you might have a whole conversation about your concerns of your child. And then you get the document and it says parent agrees with program. That is not accurate. And that's really important because that document is what, if we need to use it for evidence, that's what our evidence is. So as an attorney, I want that to actually reflect what happened and what you disagreed with. So send it in writing, ask it to be made part of the educational record for your child. It may not be attached to the IEP, but as long as it's in there when, if anybody gets the records, that's fine.
So do you ask them to say, like, please see attached in the parent input section?
Yes, like if they can refer to it. Some of them don't want to then change the IEP, but if you request a copy of your child's records, that should all be in there. Some of them will actually take what you say and put it in the notes of the document, which would be preferred. But we're not always going to get that level of cooperation. Okay. Consent is another right. So it's your child until they're 18. You have the right to consent to what's being done in school with them. Again, has to be in your native language. So one of the things you have to consent to is records are being sent. Let's say that there's an outplacement or an evaluation that requires that person to have your child's records. You have to consent to who the records are being sent to and what is being sent. Okay. You can withdraw your consent in writing to special education. You have to give consent to initial testing. So when they say there's a referral, we want to do initial testing, you have to consent to that initial testing. And you also have to consent to the initial provision of services, and you have to consent to reevaluations. So if you don't consent to the initial testing, in some cases, the district can do initial testing without your consent. It rarely happens. Even if they did, you still have to agree to the provision of services, which you can consent to or not consent to. Okay. They don't need consent to review existing records if they're going to, do a reevaluation. They don't need your consent for district-wide testing. And they don't, and this, some people are surprised at this one, they don't need your permission to place your child at a private school. So if you're in a PPT meeting, this most likely happens when there's significant behaviors of your child. The district decides that they can't handle, and they refer your child to another school that would be more appropriate for those behaviors. You don't want your child to go there. They do have the right to, in the meeting, decide to move your child. If this happens to you, consult with an attorney or an advocate or somebody, because this is a really complicated thing. You do have a couple of options to stop it. One being you withdraw your consent to special education. If they don't have your consent to provide this, they don't have your consent to move your child. But it's a real power move, because then your child has no services. So again, it's a bigger conversation. The other thing you could do is invoke stay put. That's another complicated discussion that probably would take its own webinar. So the important takeaway, I think, is if that were to happen, know that you do have ways to stop it, or at least postpone it. Okay. So you have to consent to the initial evaluation. Failure to respond within 10 days typically is deemed a refusal. They won't evaluate, and they can do it on their own if they want. That you have to give consent for services, and they must provide the prior written notice before stopping services. So again, it's when they initiate or stop doing something, the prior written notice comes in, and reevaluations we already talked about. So parents' right to independent education evaluation. This is a big one called IEEs. So if I call it an IEE, this is what I'm talking about. This again could be a whole weekend series of webinars. So we're going to kind of touch on things, but this is one of the big superpowers that you have as a parent, parental rights. So if the school does their evaluations and you disagree with their evaluation, it doesn't capture your child, whether your child was having a bad day, it just doesn't feel right to you, you can request an independent evaluation by an evaluator not employed by the school district, done at the expense of the district. Alternatively, you can secure a private parent paid evaluation and submit it to the district, where they have to consider it. This touches on meaningful participation, which is something we're going to talk about. So you can have somebody else do the evaluation and have the school district pay for it, or you can get your own evaluation, pay for it, and submit it to the district to consider. Okay, those are two different things. For the IEE, which is the one where the district is paying for it, there may be parameters that you have to meet. And by that, I mean, districts are allowed to give you guidelines for IEEs. They can't hand you a list of people that you can choose, because the whole point of this is it's an independent evaluation. At the same time, they can put parameters on it that it has to be within a certain mileage range, that the cost has to be in alignment with other providers of those services, that the person might have to, if it's a neuropsychologist, they have to have a degree in neuropsychology and those types of things. When you get those, I would read them carefully. And I have an example here. I have one that's from a district, and they provided a list of providers. This list is from 2020, and everything has gone up in price, including evaluators. So they've approved these people for what their price point was, and will automatically not allow somebody else, not knowing that the price points have really changed. And then when I looked into this document, there are things in here that are not actually legal. It says that the evaluator has to provide the written report within 60 days. I don't know if any of you have tried to get an evaluation lately, but the wait times are months, and then the evaluators are so easy, then it's another month or two before you're going to get your written documented report. So that is not a fair obstacle to put in a parent's way. If you get something like this and you don't think it is appropriate, we're going to talk about state complaints, but that is kind of a perfect place for a state complaint, to submit a complaint that they're preventing you from participating in the process by putting these obstacles in your way. And again, we're going to talk about that a little bit, but the big message from that is, if when you get these parameters, read carefully through them. And if you have somebody you can run them by, do that, because a lot of them are found to not be in actual alignment with the requirements. This state does have some IEE guidelines on it, which actually not all of their parameters are correct either, but at least it's a decent guide for you to kind of look at. Okay. In terms of their list of people, you don't have to choose from their list. How do I find a neuropsychologist? Most people find them through the parent groups on Facebook, or from advocacy groups, recommendations. You can call evaluators and ask them what their timeline is, if they'll attend the PPT, those kinds of things. So again, there's a lot that goes into that, and we don't have time for all of that. So I'm just kind of highlighting. IEs are a big thing, because there was some case law that we're going to talk about that kind of changed the direction. But in general, you're entitled to one IEE, so one evaluation each time the district conducts an evaluation with which you disagree. So if they do an initial evaluation, you're actually not entitled, if they, well, I'm going to back up. If you get it, if you go to a meeting to determine that your child is eligible and they decide not to even evaluate your child, you cannot get an IEE. So if they don't do evaluations, you can't get evaluations. If they do evaluations and you disagree, you can get them at the initial or at your triennial. So every 3 years, at least, the district has to do evaluations on your child, and you can disagree with those. So as I said, their criteria can't impose timelines or interfere with your right to ask. And a state complaint is your remedy if that happens. So when you request an IEE, they can ask you why you disagree. You're not required to answer. If you have a valid reason, I would say answer it, because they're more likely to approve it if they kind of know where you're coming from. They can't. So when you ask for one, the third bullet is, this is not a PPT decision. This does not have to be decided in a PPT. You can ask for it in a PPT, and they can say, we're not going to answer that right now, and that is fine. What they can't do is unreasonably delay that. What does unreasonable delay mean? There's no definition for it. So it may mean different things at different times. I do know that there was an attorney, a colleague, that filed a complaint because it was, I think, 46 days after the request, and they still had not decided. That was found by the state to not be an unreasonable delay. So it's not what you or I would think is unreasonable, unfortunately. The other thing is, you don't have to ask for it in the PPT. And a lot of times they don't, because it's not a PPT decision. We're going back to those money decision makers, that they're going to spend the money. They're going to make the decision on whether to approve it or not. It's not all the teachers and the PTs and OTs sitting at the table. So I would put a separate written request in, and that's where I would usually explain why I disagree, not to tremendous detail, but enough that it could potentially sway them. If you do ask and they say, well, can we just agree on an evaluator? That's a different thing. That is, we refer to it as a mutually agreeable, and it happens all the time. And it's usually a good way to go. So you say, I want an IEE, and they say, well, can we agree on somebody? If you can find somebody that you agree on, go for it. At the same time, I would still maintain my right to an IEE on that if I can. You might have to give that up in order to get your evaluator. Okay. When you request an IEE, the district has 2 choices, and only 2 choices. If you see more in their guidelines, it's wrong. They can approve it or they can file for due process against you. And I want to talk about this a little bit because that goes back to that intimidation factor we were talking about. When the district says, fine, we're going to file against you, and you get this, official looking document from a hearing officer, it's really intimidating. And it's meant to be, unfortunately. And part of that is why they're doing it. It's much less expensive for a district to grant your $3,000 evaluation than to go to a due process and fight you for it. But more and more districts are employing this strategy of going the distance and filing for due process. If it happens, don't be intimidated. The first thing that happens is you get this official looking, the district has filed against you for due process, and your pre-hearing conference is scheduled for March 5th at 12 o'clock with the hearing officer. When people call me with that, I actually usually advise them, we'll go to it and see what happens. Because if they're not scared right up front, the district might give in. The pre-hearing conference is a phone call with the hearing officer and the attorney and you as the parent. And it's just talking about what are the issues, and let's set a hearing date. That is never going to happen. You always have the ability to withdraw your request at any point, and then that makes the whole thing go away. Okay. If you were to go to a hearing and the hearing officer agrees with the district that their evaluation was appropriate and you're not entitled to the IEE, you can still get the evaluation that you want. You just have to pay for it. The district will not pay for it. When you bring it to them, they have to consider it, which again is not a defined term, but it means that you can still present it to them. So this is a little bit of a tale of what went wrong with an IEE. This was in Connecticut, and the issue was a functional behavioral assessment, an FBA, and this was DS versus Trumbull. So what happened was the student had their triennial evaluation in 2014 and was due again in 2017. And an FBA was conducted each year between that to kind of understand the student's behavior. After the 2017 FBA, the parents requested a comprehensive IEE on not only the behavior, but all of the other stuff that was assessed in the 2014 testing. The hearing officer originally denied the parents' request because the FBA only examines behavior. It went to appeal. The federal court agreed, but found that the disagreement with the 2014 evaluation was barred by a 2-year statute of limitations. So in special education cases, there's a 2-year statute of limitations, meaning that you can go back for 2 years in order to assess what you should be entitled to. You can tell the whole story, but you're only looking at those last 2 years. And those last 2 years were used as a guideline for when you could ask for an IEE, okay? So then that got appealed, and the Second Circuit, which is the Connecticut, Vermont, and New York Circuit, decided to broaden this and talk about what is an assessment, what is an evaluation. And they actually determined that an FBA is not an evaluation, at least in respect to an IEE. So the FBAs kind of went away as being able to request an IE for a functional behavior analysis, which was a really bad thing. They also held that the 2 years for filing doesn't apply to IEs, which was kind of a good thing. The board, so the school district that was fighting this, Trumbull, had actually said in all of their paperwork an FBA was an evaluation, and they referred to it as an evaluation, and the court corrected them and said, no, it's not. So this was decided in September 2020. Districts in the Second Circuit are using this to deny IEEs. And the parents, unfortunately, thought that they won because of the statute of limitation. So it did extend it to a 3-year period for your requesting an IEE. But here's a good example. The state IEE guidelines that are on the Department of Education says 2 years currently. That is not correct. That is so misleading. I've been after them every week to correct it because since 2020, it's been 3 years. So you can't always trust the information. And this was just a good example of a request that went really poorly for a lot of people. So as parents, you are entitled to records for your child under the Family Education Rights and Privacy Act. We call it FERPA. Your child's educational records are available to you. You're allowed to inspect and review. So the federal law says inspect and review no later than 10 school days after you request them. So Connecticut provides you one free copy of them. The federal doesn't. So literally inspect and review may be going to the board offices and looking at the records. Connecticut regulations provides you one free copy, and then they can charge you. And a lot of them will charge you, 50 cents a page, and they are perfectly able to do that. Electronic records make it easier, and they might be able to send them to you that way. So it's a record of, so everything in there is your child's records. It's also a record of who accesses your child's records. So if they log into the IEP, it's documented and all those pieces. If this is like, hey, I'm going to request my child's records, there's no real benefit for you to request them unless you need them. As an attorney, if I represent a child, I do request them because I want to see what the school is holding out as a child's records. If the parent has requested them the year before, I will only get that last year of records. So it gets a little complicated there's no real reason to ask for them unless you have an issue. They're maintained for 6 years. That may change based on your state after they're no longer needed to provide services, which could be exit from special education or graduation. Okay. So other records, these aren't a right, you don't have a right to these as parent records, but to me, it's important to know you have access to them. People are working with your child and you have a right to know what their qualifications are. So is the teacher certified? Is the reading tutor certified in OG or Wilson or something like that? So I always want to know what the qualifications are and ask politely first. In some instances where there's teacher shortages like there are now really significantly, a lot of these requirements and certifications can be waived. You can have situations where a long-term sub comes in who does not have to be a qualified special education teacher or something like that. So it's always good to find out. These are subject to Freedom of Information Act requests. So it's schools are government entities. They are subject to requests for this kind of information. You can also search teacher certifications online. Like I just type in Connecticut teacher certifications search, and you put in the teacher's name and it shows you what their certifications are and what other qualifications they might have. Anyone who claims to be trained in trauma informed or prompt speech or Wilson or OG should be able to provide proof that they have that. Okay. And I would ask for it. The professional certifying organizations are always a wealth of knowledge. I'll just use Wilson as an example. Wilson keeps a record of everybody who is Wilson 1 and Wilson 2 trained, everyone who wants to be included in that list. So it might not be everybody. You can call them. They will send you a list. They will tell you if a teacher is qualified. It won't include people that don't want to be on it. But if you're a school teacher says I'm a Wilson 2 and you can't find them there, that gives you a really good reason to kind of go back and question what their training is. And know how to use this information. I never want to use this information accusing anybody of anything. It's more of a clarification of what the district is kind of telling me. Okay.
Do you think you should also ask for the qualifications of those evaluating the child? So if they are conducting an FBA, should that be a BCBA?
Yeah, I always ask for a BCBA of board certified behavior specialist. I would want that type of person. So the school a lot of times will have a school psychologist do an FBA, and I would push back there and say I want somebody with a higher level of training, a BCBA. If they don't have one in district, that's a perfect opportunity to ask for a mutually agreed upon evaluation with somebody outside the school district. So yeah, your school psychologists, they only have that job really if they're approved to do kind of the psychological testing. The one area that comes to mind is there's a thing called a school neuropsychologist. some districts have them. So a neuropsych eval is a psychological eval on steroids. There's a little bit more information about how your brain actually functions. And a lot of times it can be really helpful to get. If I ask for that and the district says, well, we have a neuropsych in district that can do it, there is a difference between a school neuropsych and a private practice clinical neuropsych. The school neuropsych cannot provide a diagnosis, which a lot of times is what you're looking for out of that. So just know that there is a difference. But if you've got a school psychologist doing evaluations, they are generally able to conduct those.
Great. I have one more relevant question for this topic.
Sure.
Can I ask for and expect to see documentation of a teacher's certification?
So again, you can go online and you can see what date they receive their certification, when it expires, and what level they have, and if they have any a special education certificate or a reading interventionist, that kind of thing. That is all online. So I don't know that I would ask for it unless you couldn't locate it online.
My understanding is the district doesn't have to, do they have to keep those certifications on file?
I'm not sure if they have to. I've never had a problem getting that information. I have FOIA'd a lot of things, and sometimes you get more than you want. Sometimes you get very minimal. The way to combat that, there's not a really great way to enforce it. So the more information you could find yourself, kind of the better. So I would check the online sites first and see what you can find.
One more question here.
Yep.
Is there a state law requiring the teacher being certified in Wilson OG in order to teach it?
No, there's absolutely not. There's no requirement, but well, I shouldn't say absolutely not. So Connecticut actually does have a law from 2017, I think, that says anybody holding themselves out for a certificate of a reading interventionist must have training in that, including a practicum. Once you get to that level, that really is like an OG associate level or a Wilson 1 kind of person. That statute has never been enforced. So if you're in Connecticut, there's a whole big right to read legislation going on and waivers and all kinds of things. This is part of it. And one thing I'm doing is I'm including that legislation in my meeting, my PPT meetings. When they say this person will be providing it, I'll say, well, does this person have this statutory requirement? They will say, no, they don't. And I'm noting that for the record. I can't fight it right there, but it goes back to keeping a record of what the district is and not doing appropriately. So I don't have the site. I will send that to Jen and we can include that in any of the stuff that goes out. I know a lot of lawyers can like cite these things off the top of their head. I'm of the age where when I remember one thing, I lose another. I can always look it up, so I'm not going to worry about it. But there is that. That being said, a lot of districts have these, the weekend warrior workshop of Wilson or OG, where you get 30 hours of training and then they're suddenly able to teach your child. For those things, I go to the Wilson website or the Orton Gillingham Academy, and I show the language from them that says that is for a classroom education, general education, setting. It is not for remediation. And I try to use that to get somebody with more training. There's no good really like stick it to them at this point way to enforce that the person delivering services actually has to be trained, which is ridiculous. I have said in meetings, like, would you go get your hair cut from somebody who is not appropriately trained? Like something at that minimal level. Well, why would you have somebody teaching your child these skills? So long answer is, other than that unenforced legislation, there's not a lot of good ways to enforce that. Hopefully that is changing on the horizon.
And as a follow-up to that question was, why would we then ask for the certifications if there's nothing really needed to teach, like as reading?
Because you want to argue that that's what your child needs, and you want to get on the record that your child requires somebody actually trained in the remediation, because at some point when you've got somebody like Jen or I fighting that battle, it does give us some leverage. And at some point it's going to be shown that people really actually need this training. I know that we are working on getting that legislation to actually be enforced, which would then require, so then we're not necessarily looking for OG or Wilson. We're looking for, you have to have this level of training with a practicum, which is the equivalent of that. So it's kind of asking for it. I used to ask for at least an OG associate level person. I've changed my tactic to asking for somebody in a, that meets the requirement of this statute that we have in Connecticut. The other one people use is the International Dyslexia Association has a definition of somebody who is qualified, and sometimes we'll use that as defined by the International Dyslexia Association, which again includes at least 60 hours plus practicum plus all of the other stuff that comes with a highly trained person. Okay.
Thank you.
So as parents, your rights are, as we've discussed, that you can enforce them through filing complaints. So we've got a state administrative complaint. This can be filed by anybody. You don't have to be the parent. You don't have to file it necessarily about your child. Like those things I was talking about, the guidelines, you can file about a district's guidelines without it having to be about your child, kind of thing. They must be completed within 60 calendar days, barring extensions. And there's always extensions in any of these things for whatever reason. It has to be filed within 1 year of whatever the event was that occurred. State complaints can be good tools. There's got to be, some kind of violation of the IDEA. You can't just not like what they're doing. One of the issues with them is you have to ask for something, and what they may give you is they may say, go back to PPT and discuss it with the team. Well, that didn't work the first time around, so it may not work the second time around. Sometimes filing the complaint is just enough to kind of nudge the district in the right direction. You can look online for the decisions for them and kind of see what people file for. The other one that you've probably all heard of is due process. Due process is the parent right to essentially sue the school district. We're not in court, we're in an administrative hearing, so it's a little bit like court, but not exactly. Only if parent or guardian or the district can file for due process, so it's not those systemic things that we talked about for the state complaint. And it has to be relating to the proposal or refusal to initiate or change identification, evaluation, or placement. So hopefully that's little bells in your head are going off about prior written notice. This is why prior written notice is really important, because this is where these things are documented. Due process, we could spend a long time on. It goes to a hearing, which is like a mini trial. There is evidence, there is witnesses, there's all of that kind of stuff. On a much less formal way. There's hearing officers, there's not judges. It's usually a very small, it's just the attorneys and the director and the parents. Yes, you call witnesses and there's cross-examination. Very, very few cases get to that point. Less than 3% in Connecticut get to a due process hearing. You can look up on the state website the decisions. You can see who the attorney was for the district, who the attorney was for the parent. A lot of parents go pro se. If you see that, that means the parents represented themselves. The win-loss rate for those is usually around 50%. The parent side is usually a little less, unfortunately. Before you get there, there's a lot of things that happen. We go to mediation, you have resolution sessions. Most cases, 97% of cases either get withdrawn or settled before they get there. Okay. Office of Civil Rights is another way to file a complaint. OCR, there's a federal and there's a state way to do discrimination complaints. And those are really based on discrimination. So your 504 kind of discrimination on disability or race or any of those things, it is another way to file a complaint if you're having an issue. I threw in bullying complaint because I think that this one goes undocumented really a lot because the schools don't want to acknowledge it. If your child is bullied, you should file a bullying complaint and document it. A lot of times there'll be the phone call and the visit to the principal's office, and then everything kind of goes away. The thing that you won't get out of this is a resolution as to what happened to the bully. There's privacy reasons that the district can't talk to you about what happened. And I know when your child is bullied, it's really, really emotional. People get really fired up and then they want to know what happened, and that's not going to happen. Um, so I just wanted to mention these because I do think documentation is important. And the other little nugget I will throw in is a lot of bullying happens on the bus, and you will hear from the district that they can't share with you the bus recordings. I hear that all the time. That is not true. That is absolutely not true. You are entitled to that as an educational record of your child. If they can, blur out other kids, they are allowed to. If they can't, you are allowed to see that. So if you ever have a problem with that, know that it is your right.
In revisiting the bullying documentation, is there a certain form you need to fill out, like state complaint, or you just email the school?
So school districts generally have a bullying form on their website. It doesn't have to be their form. Anytime they offer you a form, it doesn't have to be their form. Districts have a referral to special education. You can just send an email. The same with a bullying complaint. I would just say, this is a formal bullying complaint, and state what happened. Okay. So parent meaningful participation is another parent right. And I included a couple of the places you will find these things. So your presence and opportunity to participate at a PPT is a parental right. The development of the IEP, the team must consider the concerns of the parent. You are an equal member of the PPT team. Any parent has been to a PPT probably does not feel either of these things. It feels like the 12-1. It's really not, because as I mentioned, your child better than any of these people. The presence and opportunity is important because they can't schedule the meeting without you. They've got to give you sufficient notice. You can waive that if it's convenient for you. They have to make efforts to make it convenient for you. That does not mean that they're gonna have them on Saturdays or at 6 p.m. or at 6 a.m. They have contracts with their teachers and their unions that require them to be not in school for a lot of hours. So it's not to that level. But if they schedule it for 3 o'clock on Friday and you can't attend, they need to reschedule it. You need to communicate that to them. Okay. You can also call for a PPT. A parent can call for a PPT at any point. I would use it sparingly. You can probably get a lot done with team meetings versus calling for an official PPT if you're having an issue with your child. But I get so many clients when I look at the records, I see there was one PPT every year for this child who's had a tremendous number of issues, and the parent may not have known that they could call for a PPT to discuss this between the annual dates.
I think this here is one of the most important pieces of information for me, particularly if your child is not yet in special education, right? You can call for that PPT or another state's IEP meeting, even if if you want your child to be considered.
Yep.
For eligibility or for an initial. And I think some parents don't know that when, for sure, general ed student, but yes, you still have that opportunity.
Yeah, I have a client now that as I'm reviewing the records, there's, they went to a fall conference and they said, should the kid be tested? And the teacher said, no, they're fine. We're doing fine. 3 or 4 months later, the teacher sent in a referral for special education. That's a violation. Like they were aware that something was happening, and the parents probably didn't know that they could put that referral in. So, and what that can look like is just an email to the special education director. I'm concerned about my child. I would like to request a referral to special education. That will kick off the clock for them to schedule a PPT and discuss whether or not to evaluate your child.
And
Okay.
you made the point too with the child maybe who's struggling to read, right? This is where our focus is. Please, do that early and do that often. If you need your child to be evaluated, do not wait. You have
And
that.
the other important piece here is it's not just about the academics. You'll hear all the time in school, well, they're getting all A's. Like, what's the problem? Behaviors are an issue. Anxiety is an issue, especially nowadays. All of those things can be reasons to call for a meeting. And the purpose of the IDEA is for the whole child, to get them to further, secondary education and employment. You can't do those things if you're hiding in a corner because you're so anxious. So it's not just about the academics. If you have concerns, you can put in the referral. Um, So providing you information prior to the PPT, I see this one on the parents groups all the time, that people get all in a huff because they didn't send me my documents, 5 days before or 3 days before, whatever it is. Other than the initial PPT, they are not legally required to send you the data prior to the meeting. Okay. You should request the data at least 3 days prior to the meeting. So when I'm talking about data, if you're going to an annual, anything they're going to present that is data regarding the progress your child is making, it's progress monitoring, if they've done any evaluations, those things are dense and they're lengthy, and you as a parent need time to absorb them and process them so that you can go talk intelligently about your child at those things. If they present them to you at the meeting, you're kind of flipping pages and going through, and it can be really disconcerting. So they don't have a requirement, but you can ask, and they most all the time send them. Okay. Um, Another parent training is a thing, and this is really not well known, that your child is using all of this technology at school and you don't know what they're doing and how to use it. You can ask for parent training, and the AT person or whoever it may be will meet with you and go over it and install it on your iPad so that you have the same kind of technology. This could involve people coming to your home, consultants, if it's ABA or something for a child with autism. um, they may pay for conferences. If you say, I've found this conference that I would like to attend to better understand my child's disability, and present it to the special ed director. Again, I wouldn't do this at a PPT because it's not really their decision. But parent training is a thing, and it's probably one of the lesser known parent rights. So some red flags, when you're in the meeting or you're talking to somebody, we don't do that here. So the I in IDEA is individual. It's got to be about your child. So when they say we don't do that here, or our ESY program is for 4 weeks and it's from 8 to 12 on 4 days a week for every child. That is not individualizing anything, and it gives you the ability to kind of question why your child is being put in a classroom with all of the other kids that have this disability. That's an issue that at least deserves a conversation. It may work for your child, so I'm not saying it's wrong, but it may, it just would require you to kind of say, dig a little deeper into that. Similarly, we do that for all of our students. Well, you're talking about your child, and that works in the reverse too. Sometimes parents will come to me and say, oh, this school, they're doing this with all of these kids and this is happening and this is, and I say, well, what's happening with your child? Because that's what we can address. We can't address everybody all at the same time. There's really no class actions in education, unfortunately. When you're told that doesn't need to go in the IEP, it really does. Like, there's no harm in putting something in the IEP, and if it's not there, we can't prove it happened. We don't see that in school. So your kid comes home and they completely melt down because they've held it together all day, and they're not seeing it in school. That still matters, and that needs to be addressed, because something's happening in school. Of course, your child's going to lose it at home. That's where they're comfortable and where they're going to feel safe about kind of that kind of stuff. So when you hear we don't see that in school, I would just make efforts to kind of document it, which could include, video of your child, or talking to your child. One of the things I think people don't do enough is talk to their kid about what's going on during the day. Are you having meltdowns? Are you getting frustrated? Any of that kind of stuff. And
I
this
think
is kind of, yep.
what I was saying there, I think that's really important information too. Like, we have our clients ask a series of questions to their children, and they're actually very surprised what the response is from the
Yeah.
child. No idea that they felt so embarrassed. They had no idea that they wish their teacher knew they had dyslexia, et cetera. So I think it's really important to have those conversations.
And know that your child can come to the meeting. I don't recommend it with really young kids. I mean, if they have something to say, I would record it and then show it at the PPT. But when your kids get to older middle school, high school, it can be really powerful for them to come in. And what we do a lot is we'll have them come in for the first 10 minutes of the meeting and talk about how they're feeling, what they're experiencing, because we don't want to put them in a position of sitting in the room having everybody talk about them. And as the parents, you also want the ability to speak freely and not have your child there. So either the beginning of the meeting, the end of the meeting, a lot of times we'll have the kid come, and it can really sway people in the room when they hear what the child is saying.
For sure. And there's a follow-up question about parent training. Where does it say about parent training? I know it's an IDEA. I don't have the direct.
Yeah, again, I don't memorize these things. But we can put that in the notes that we send as a follow-up. So the purpose of the IDEA is to ensure that all children with disabilities have available to them a free, appropriate public education that emphasizes special education and related services designed to meet their unique needs. Those are important words, and prepare them for further education, employment, and independent living. So I would keep this phrase handy. It is the purpose of the IDEA. And when they say, well, he's getting A's and he's doing fine and he's melting down all the time, that's where you say, how is this preparing my child for these things? It's not just about the academics. So what does using your rights look like in practice? When you go into a PPT, which is where most of us encounter the special education process. So you want to know what the purpose of the meeting is. Are you reviewing evaluations? If you are, you want them in advance. Are you going to an initial, to determine if your child might be eligible? You want to have any data that you might have and share it with the district. The information should go both ways. And again, you have the right to request a PPT. Requesting your data 3 days ahead of time. So what happens if you get to the meeting and they present you with this data, even though you asked for it? You have choices. You always have choices. You can remember that after the IEP comes out, you have a period of time that you have to disagree with it. So you're not deciding things in that moment that necessarily have to stay the way they are. So you can decide to postpone the PPT and walk out of the room. I've sat there for 10 minutes and read the reports and made everybody wait for me when I'm feeling particularly, not hostile, but not cooperative. And I've actually done that as a parent. I don't think I've done that as an attorney, because unfortunately, when you're an attorney, they will send you the stuff ahead of time. Prepare a parent statement. So when you're going in, these things can be really emotional. You might forget what forget what you want to say. So preparing something ahead of time, you can submit it to them the night before. You can submit it to them the 3 days before. You can get to the PPT and read it into the record. And you always want to ask that it be included in your child's educational record. And it could just be outlining what your concerns are, so that when you get the IEP and that tiny little box says parent was happy with the program, that's not the case. You can record a PPT. You want to give advance notice that that's your plan. It's just the polite thing to do. The districts will also record, which is fine. If you want it recorded and you don't know how to do that, ask them to record it and share it with you. You don't want to record things in secret, okay? Some states have a one-party permission, so only the recorder needs to know. Most states have a two-party, like Connecticut. The person you're recording has to know that you're recording. So it's just always good to kind of let them know in advance. If you disagree with anything of substance, you want it in that prior written notice. So those things would include the services your child's getting, the length of the services. You want 5 days a week for 45 minutes. They're going to give you 2 days a week for 30 minutes. You want it documented that they did not put in the time that you were requesting. They deny ESY, eligibility, or evaluations. So things to know, aside from, everything that I've just told you. There's lots of places that you can find this. And like I said, I don't memorize this stuff because there's so many places I can get it. Understood is a great website. They've got a lot of tips and tricks and just direct information. Rightslaw.com. If you have not been there, go there, please. This is on my desk all the time. This is the new version, so I only have a few tabs in there, but it's highlighted, it's tabbed. When I used to go to PPTs, it would come with me. They've got several books that are aimed at parents and advocacy, really great resources. Their website is free and terrific. They also offer trainings. Jen and I were recently at a training. I go to trainings all the time because I can always absorb more and know something that I didn't know before. So they have some, and I'm not a spokesperson. Pete Wright, who started it, he argued one of the premier Supreme Court cases many, many years ago, and he's still very active. COPA.org is the Council of Parent Attorneys Advocates, and it is a national organization. I think parent membership is either free or very minimal cost. There's an annual conference, which is actually next weekend. And there are levels for attorneys and advocates and parents, really great information. They do offer a lot of trainings. I think Jen is currently in one of their trainings. I've taken a bunch of their trainings. So just really good. That book I just showed you, read it, highlight it. If you go in person, bring it to the meeting so that they know that you know what you're talking about. The other book I recommend, Your Special Education Rights, are written by attorney Jen Laviano and non-attorney advocate Julie Swanson, who are both practice here in Connecticut. Just a really good, like, what your district's not telling you, what goes on kind of behind the scenes. They are in the process of writing a second book. I don't know exactly what it's on, but I'm sure it will be great. So again, I get nothing from promoting these. I just find them really good resources and accessible to parents. It's written in language that's really kind of understandable.
Yes, thank you for recommending that one. I just read On Vacation.
Yeah. And then I put this in because everybody should be familiar with what this is. This is the bell curve. This is what shows you when your child is average. If you don't know, when you buy the rights law books or you go on their website, they will explain to you what this all means. It's just when a district, when you have your child's testing and they say your child is average, the average range is ginormous. It's 25 to 75%. To me, there's a really big difference between a child who's at 25% and a child that's at 75%. So you want to know what all the numbers are in order to kind of get a better picture of what your kid is. So this is just a good thing to be familiar with. So in summary, knowledge is power. Hopefully you have a little bit more. You are entitled to all of the information that your school has when making a decision about your child. The IDEA is about individuals. So again, speak about your child, not what's going on in the grade or in the school or any of that kind of stuff. Know when you need help. We all need help. I rely on colleagues all the time. We bounce stuff off each other. We run into new scenarios. So if you need help, there are resources. A lot of advocates and attorneys will answer some questions if you have them. Know that you will be emotional. It's the number of parents that get emotional in PPTs. I used to cry in my kids' PPTs all the time. And they won't be. They are not emotional about it. So you're already coming in at a little bit of a disadvantage potentially. Document everything. One of the attorneys I work with, Robin Keller, says the E in email is for evidence. And if it's not in writing, it didn't happen. That Pete Wright says that all the time. So it's very true that when you get to working with advocates and attorneys, if something's not in writing, we can't show that it happened. So schools are really, unfortunately, known for calling you if there's an issue because it's not documented then. They call you, and if they don't get you, they call you back. If that happens and you have a conversation about something that happened in school, follow it up with an email. We just had a conversation whereby you told me, and summarize it, and what we decided was this, so that there's a record of it. It's now in your child's educational record because it's an email that's got their name on it. You just want to really document everything. And in knowing kind of your rights, you want to pick your battles because there are times parents will contact me and say, I'm supposed to get this within 5 days and it took 8 days. And they were supposed to do this within 15 days and they took 27 days. That is unfortunate, but they're not things that are going to tilt the scales toward you and when it comes to exercising any of these rights. When you go to a hearing or you're in that final level of, being decided, the IDEA does not give a lot of credence to procedural violations. Procedural violations refer to the timelines and the procedure of the whole thing. The substantive violations are actually the services being delivered to your child. In order to find a violation of FAPE, it's really got to be in that substantive realm. So the not meeting the timelines, it's frustrating, and I would definitely document it, but it's not the battle that you really want to fight. Okay. And then I just wanted to mention the current legal standard. So Andrew F. was a case that was decided by the Supreme Court in 2017. Supreme Court cases regarding education do not come up frequently. The courts don't know enough about it where they really want to kind of delve into it. This was one that they did. And they clarified the standard in a good way. The standard before was really a de minimis, like not a lot of educational benefit had to be conferred upon your child. Now it's to enable a student with a disability to make progress appropriate in light of his or her circumstances. I use that all the time. Well, what are my child's circumstances? Are they really, high functioning, but they're not achieving? Fine, they're getting good grades, but what are they capable of? It's not necessarily the best, but it's in light of your child's circumstances. And again, whether or not they're performing at grade level. Every child should have a chance to meet challenging objectives. So you want to look at the goals and objectives. Are they challenging? And an IEP must be appropriately ambitious in light of the child's circumstances, just as advancement from grade to grade is appropriately ambitious for most children in their regular classroom. So this is the current legal standard. And then we're back at questions. So if you want to reach me, this is my email, my website, and I am only on Facebook because I don't do a lot of social media. But that's how you can contact me.
Excellent. Thank you, Attorney Heneghan.
Sure. So I will
Great
stop
information.
sharing.
And I sit here and think, oh, I wish I knew all those things years ago, right? When I started my journey. So hopefully parents are at the beginning of their journey and they've learned something new today that will help them. And I will be happy to share your information. And we have a couple of follow-ups that I'll include in the follow-up email. I did pop on the side here, the IEP parent training information from IDEA, and I can include that in the email as well. I guess one final question is like, how does a parent know when it's time to reach out to an attorney?
I mean, there's a lot of different stages that you can get involved. Some attorneys don't necessarily like to be in the beginnings and the PPTs. I like going to them because I'd like to approach things more collaboratively and try to kind of solve problems before they get really escalated. So I think part of it is just if you don't understand what's going on, you really are just your spidey senses are tingling that something is not going well. It's certainly worth a phone call. I do consults all the time. I don't charge for consults because I want people to kind of have access and get information. CPAC is a resource in Connecticut, the Connecticut Parent Advocacy Center. Sometimes I hear people say they're not really accessible, so I'm sorry if they're not. It's a hard question to answer because there's so many facets to this. If you are looking for an outplacement for your child, I mean, that's probably one that I would say consult an attorney. Because if you don't do things in the right way, you could be cutting off your access to any kind of reimbursement if that's the way that it goes. It's all in the books on, what you need to do in order to do it. So again, I encourage you to kind of flip through, know the law a little bit. And then, again, I don't have a great way to, I don't know, Jen, what's your experience with, when do you say people should call you?
I mean, I do think as a parent, we have that gut instinct that something is not quite right. And that's, what we went with. We started with an advocate first and kind of worked on understanding the process and then reached out to an attorney for our son who is dyslexic. So
Yeah.
you're right, it's different everywhere. But if you're seeing that there are major red flags, it's certainly time to consult. And Attorney Heneghan's been great, even at late hours recently. So thank you for that. But definitely reach out if you need support to either of us. And thank you again for your time today.
You're very welcome. Are there any other questions that you want me to?
I think that was it. There was one more. Oh, here. Does the district need to put in writing if they're changing their 12-1-1 class to include all needs versus 3 separate programs? I'm not sure on that one. Does the district need to put in writing if that? So I think if the district is changing placement, I'm not sure if that's placement.
So, if they're changing the groupings of the classes, that's not really a legal issue. If they're changing the program that your child's in to a, you know, an inclusion classroom or something, then that's more of a change in placement.
Mhm. Okay. And then there was one question, I'm a bit unclear, but there was some concerns about cost. I'm not sure if that's in regard to legal costs, but I think it is worth mentioning. It made me think of Self, if you want to.
Yeah, definitely a great resource. So it unfortunately it is expensive to hire an attorney. Less so an advocate. They are at a lower price point, and very, very valuable to the process. And any, you know, good advocates know when it's time to process to an attorney. So as Jen said, sometimes you start with an advocate. You know, I have an advocate in my office, Stacy TA, and sometimes cases flip back and forth because something happens where they need an attorney, but then we get things settled down so we can go back to an advocate. So you're not locked in forever. It's hard to say what the costs are because each case is so individual. Like I bill in fixed fees to kind of give people an idea. So when I hear from you what your case looks like, I can try and give you kind of an idea. But we've all got kind of different hourly rates and fixed fees, so it's really hard to kind of give you an idea without knowing more details.
Yeah. There's one more question here. Do you recommend going to special education PTA as a starting point? Yeah, absolutely. I think that could be a great resource in your
Yeah,
town.
districts that have them, and they can be kind of powerful. I think that's where you have to just be aware of that individual piece. Like the PTA is kind of representing all students. If you've got an issue with your child, you just want to be careful because you can't address things necessarily systemically. But usually a district that's got a SEPTA, sometimes they're calling them a special education PTA, has got a lot of good resources, or they know where to go to ask the questions. They may have, you know, evaluators, and that's where a lot of times you can get those lists of evaluators and things.
Mhm. Absolutely. Just in closing, two things. I want to circle back to Self, Special
Oh,
Education
yes, I'm sorry.
Fund for Connecticut and I believe Westchester County, New York. They provide grants for both advocates and attorneys. So that is helpful. You could look at Self. And then also you mentioned special education PTAs, or in our area, there's SpedNet. I'll just give them a shout out. They have a wealth
Yeah.
of information.
I want to mention Seek Connecticut too. Yeah. So Seek,
And
special education equity for kids in Connecticut. Again, parents are either free members or a minimal fee. It is a membership group. There's actually a conference coming up in April for providers. So speech and language, OTs, attorneys, advocates are having tables so parents can kind of look at the services. They are very big on legislation. They've got a person who is, you know, working with the legislature. They're very well versed on the legislation and what's coming, and have helped push through some different legislation in the state of Connecticut. So you can go on and join them. I would encourage you to look at COPA and, you know, consider being a member there. Check out Self, as Jen said, they offer grants, monthly cycle of grants for advocates and attorneys, which can help you, you know, get somebody, if you're not in a financial position, be able to do that.
yep, and in
So,
Connecticut, we have smart kids,
yep.
learning disability. So yes, wealth of resources online and in your community, and then reach out if we could be of help. So thank you.
Thank you.
That you've been more than generous with your time, and it's about 1:15. There's one more question, but I'm going to connect you with her directly if you don't
Okay.
mind. Okay. All right.
Very
Thanks so
good.
much.
Thank you.
Bye.